Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Today we are on celebrity estate planning, and for today's episode, we are going to dive into what happened following the death of Michael Crichton, which is a name that you may or may not immediately recognize, but among many other huge hits, he is perhaps most known for being the author of Jurassic Park. So if you don't recognize his name, surely you recognize the movie Jurassic Park. And he was the author to many other books too that also turned into some mega films. So there was Jurassic Park, of course, The Lost World, which I think was Jurassic Park sequel. Congo, which I totally remember my sister and I watching and loving. Rising Sun, there was Andromeda Strain, etc. So the guy was a heck of an author. At his passing, though, he left a little bit of a mess. So he may have been a man good with words, but that did not really extend into his estate planning endeavors. But first, as always, let's talk a little bit about Michael as a person first to get a better understanding of him personally. According to his Wikipedia page, he actually hailed from Chicago, Illinois, so a fellow Midwesterner. Michael was born in 1942, but he ultimately at some point moved to New York and was raised in New York by his parents. Later in life, he attended Harvard University and obtained his bachelor's and medical degree. So, smart cookie, right? Throughout his adult life, he married 5 times, with 4 of the marriages resulting in a divorce. One of his spouses, Anne Marie Martin, who he was married to, I think, for the longest duration, was the mother of his first child, a daughter by the name of Taylor Ann Crichton. Taylor was born in 1989. So fast forward some time, his 5th wife, Sherry Alexander, who he was married to when he passed away, Michael and Sherry had Michael's 2nd child, whose name was John Michael Todd Crichton. Interestingly, which we'll get to in a little bit, Sherry was pregnant when Michael passed away. She was pregnant with John Michael. So Michael, like Dad Michael, never got to meet his 2nd child, who was born in early 2009. Though, as you may suspect, that did end up causing an issue with his estate, so more on that soon. Now, another issue that we'll talk about is that Michael and Sherry executed a premarital agreement prior to their marriage. Now, the formal word is premarital agreement, but many people refer to it as a prenup. And a common misconception about prenups is that they only deal with assets in the event of a divorce. But what a lot of people do not realize is that prenups also often deal with things after either party passes away too. So we'll get into that in a little bit, I promise. But just know there was a prenup in place between Michael and Sherry. Unfortunately, after a long and wildly successful career, and fast forward time to early 2008, Michael was diagnosed with cancer, and after he attempted chemotherapy treatment, Michael passed away on November 4th, 2008 at the age of 66. Sadly, according to his Wikipedia page, his doctors actually expected him to fully recover. Sadly, they were wrong, and he ended up passing away. And after his passing, it was discovered that he at least did not die without an estate plan. So rather, he did have an estate plan, which included a last will and testament, as well as some trust planning. But the main issue, among a few other things, was that it was a little bit outdated. According to the Probate Lawyer blog, which is a blog that is prepared and published by Andy and Danielle Mayoris, who are sort of known in the estate space for shining a light on celebrity estate planning. So according to them, Michael's estate plan had a provision that said, quote, "I have intentionally made no provision in this will for any of my heirs or relatives who are not herein mentioned or designated. And I hereby generally and specifically disinherit every person claiming to be or who may be determined to be my heir at law, except as otherwise mentioned in this will," end quote. So, to me, in my professional opinion, that is really crystal clear that he was basically saying, like, no one is inheriting anything unless they are specifically mentioned in this darn document. Though, where there was a little room for argument is, did he really mean to specifically not include his unborn son, John? Did he truly mean to do that? Or was it just a failure to update his plan? Or maybe did he just not read and fully understand the document and what the consequences would be, and specifically in regards to his unborn son, John? So, in an interesting turn of events, you could probably see this coming from a mile away, Sherry Alexander, Michael's widow, and mother of their unborn son, got the court involved, and she got the court involved to ask to become legal guardian of their son, John. Therefore, if he were to receive an inheritance, and she further later claimed that John should be considered to be an heir of Michael, that she should be the manager of it. She should be the trustee of any inheritance that John would get from Michael's estate. According to the blog, it was noted that some have claimed that Sherry doing this was in violation of the prenup, but nonetheless, she was willing to fight the battle and got the court involved. So, of course, Michael's daughter Taylor had something to say about this filing. She opposed Sherry's argument. It was shared, too, on an article on United Press International that's linked in the source links for this episode, that Taylor even further argued that Sherry should not be a trustee of Michael's trust. You see, a trustee is sort of like an executor of a will. They are in charge, not necessarily always a beneficiary, but they are in charge of things. Like, not always that they're getting something. I hope that makes sense. So Taylor, Michael's living daughter, was trying to also get Sherry off as being someone in charge. Sherry's attorney, his name is Adam Streisand, had something to say about that. He shared, quote, "Taylor has absolutely no legal or factual basis to make any claim that Mrs. Crichton has done anything other than faithfully discharge her fiduciary duties to all trust beneficiaries, including Taylor Crichton." He further shared, "It is sad that Taylor Crichton would dishonor her father's wishes and wage such an undignified attack on her family members, especially actions that would attempt to deprive her own brother of his right to share in their father's estate. We have absolutely no doubt that Mrs. Sherry Crichton will continue to serve as a co-trustee of her late husband's trust." End quote. Ultimately, Sherry's legal team argued to the California probate judge that the clause in Michael's will that expressly disinherited children was different than him accidentally omitting a child. That was Sherry's legal team's argument. They were hanging their hat on something called a pretermitted heir, which, according to RMO LLP, which is a law firm out of California, this is how they explain what pretermitted heirs, that's a mouthful, what they are. They say it is simply a child who became the decedent's or was born to the decedent after the decedent's will or trust was created. And here's an example. Mary creates a will and trust outlining her wishes after her death, including distributions to her 3 children. A year after creating the will and trust, Mary has another child, yet does not update her estate plan. Years later, when Mary passes away, her family discovers that she never added her youngest child. That child is pretermitted. End quote. So with all that being said, it appears that Sherry remained as trustee, so that was something that Taylor was trying to argue. So back to who's getting what and whether the unborn son at the time of Michael's passing, John, would inherit anything. When all was said and done, the judge appeared to side with Sherry and not with Taylor, Michael's daughter. And the judge allowed John, which was a baby at the time of this all going down, to inherit from Michael's estate and trust. Now, the tough thing about this part of the story is that no one will know what Michael would have wanted, right? We could have assumed he would want some portion to go to John, but that would be a straight up assumption. Or maybe Michael assumed that Sherry could and would financially take care of John. And maybe he did intend to not include his unborn child at the time of his estate. Who knows? Only Michael knows, and he's not with us. Instead, what would have been far more appropriate would have been for Michael to update his estate plan when he found out he and Sherry were expecting, and either update it to include the baby or update it to exclude the baby in writing. That is what he should have done. And I think I read somewhere that Adam Streisand, which is, again, Sherry's attorney, argued that he was in the process of making those changes. So just a little fun fact tidbit. So had Michael taken the time and money to update his estate plan, just consider how much time and money that would have saved. After he passed, a court battle broke out between Sherry and Taylor, which of course took quite a bit of time. But also just the mere cost of the litigation likely took a toll on the estate value. And when it took a toll on the estate value, that ultimately decreases the eventual inheritances from their father to Taylor and John because of the legal fees. Beyond even the time and money, it's likely that the relationship between Sherry and Taylor was at least considerably impacted, not in a good way. I didn't really find anything to tell me whether Sherry and Taylor are now on good terms, but at the end of the day, had Michael updated his estate plan, he probably would have saved the conflict and the corresponding hurt feelings because of the conflict. It's just not a great situation all around, right? One last quick note before we wrap up here. So remember me saying that Michael and Sherry had a premarital agreement, aka a prenup. Well, it was confirmed they did because as a TMZ article shares, Michael and Sherry's prenup was executed on April 22nd, 2005. And in that agreement, Sherry was to get $1 million per year for 9 years if they got divorced. But in the event Michael died, Sherry would just get the lump sum or the balance of that $1 million for 9 years. So even though it kind of on the surface seems that Michael didn't leave much or anything to Sherry, that's not necessarily true. She did get a portion of the estate due to the prenup spelling that out. So at least that worked okay. It seems like the prenup did its job. But something to know is before the kiddos got anything, they probably had to pay taxes, like I already said, legal fees, etc. And then the remaining balance went to the kids. I did read one article mention that there was some portion of an estate that may have went to some siblings and friends, but I only saw that in one article. So because I didn't see it anywhere else, I don't want to report that there was more that went to other people besides the kids. Maybe it did, maybe it didn't. That's kind of the beautiful thing about a trust, is those sort of things are private. So it seems like at the end of the day, things ended up working out. It just required some court and drama to get there, right? So like I said, I would be really curious to know if Taylor, Michael's daughter, talks to her brother and or Sherry. I really hope they do. I hope things eventually got resolved and things are on good terms. But as many of us know, oftentimes these messy estate cases result in hurt feelings and choice words. And because of that, sometimes relationships fizzle. Alrighty, I think we are ready to wrap this episode up. Next week, we are back to a cautionary tale episode where we talk about real life clients, real life cases that I or my office have worked on. So during that episode, we're going to go into a story that I suppose is sort of like a success story, not a cautionary tale. But nonetheless, without some planning and them getting their little tushies in my office, it could very easily turn into a cautionary tale. It's a good one because, long story short, it's about a divorced couple who are following the divorce actually like best friends. They share 2 children together. And basically what they were wanting is that they did not want to combine their estates, but they wanted their estate plans to place nicely with one another for their children. So the fact that they thought about that idea and executed on it, just chef's kiss. So next week we'll talk about that. So until then, my friends, take care and be well.